Blessings in Jesus' name. So in this quick little video, I just want to summarise how corruption has entered into the High Courts of Ireland. Now, currently, Stephen Tallon versus the DPP has gone before the Court of Appeal. They only spent like 2 hours, 3 hours one morning discussing the proportionality of a civil order, completely ignoring the constitutionality of the sections under which it was first made up, even though that was brought before the High Court of Ireland, and they ignored it also after they had scheduled it for testing the constitutionality of those sections. We see that they're failing in many places. I was arrested for preaching the gospel of Jesus and singing a hymn with the name Jesus in it. I was brought before the district court, civil court, where members of An Garda Síochána have no jurisdiction. These sections of the Criminal Justice Act 2006 purport to place a guard where he has no jurisdiction. They purport to forego certain precepts and fundaments and basics and imperatives of law, which are presumption of innocence, impartiality, jurisdiction, everybody been held equal before the law, and due process of law or court. And so, when you place a member of An Garda Síochána, you tell him in the Criminal Justice Act that he can now operate in a civil jurisdiction, you have committed high treason. It's nothing short of high treason. So it's no mistake or no accident that they're now running away from testing the constitutionality of the sections under which they first tried to summons me to a district court on the basis of mere hearsay. And I'll explain this mechanism to you. In the Criminal Justice Act 2006, in section 113 and 114, described is an adult behaviour warning. The adult behaviour warning is supposed to be some kind of de-escalation mechanism. The problem with it is that it requires a guard to play judge, jury and executioner outside of his jurisdiction in a civil matter. On the one hand, the guard is saying, I can't arrest you because you haven't broken the law, but on the other hand, he's saying, you must stop doing what you're doing. What am I doing? What this person said you're doing. Why am I saying that? Because the guard has done nothing but gather a complaint from a member of the public, assuming it to be true, ratifying it with a signature, and then telling you must cease and desist from that activity, even though he hasn't actually seen any crime being committed. So he has foregone due process of law. He's foregone due process of court. He has abandoned impartiality, because now he's deciding at the side of the road that what this person has said about this other person must be true, such that I must go to the station and print out a piece of paper which says adult behaviour warning on the top of it. I must take down what this person says about this other person, then I must ratify it with a signature. And I must pretend that it has the apprehension of a summons at the end of it, as would a cease and desist order or a civil ban, if it were, of course, lawfully arrived at in the first place. But when we say that we have certain rights and it's to be presumed that we can engage them in society, it's not only for guards to allow us to do so and not interrupt us, it's for them to uphold those rights and prevent others from trying to harass us while we're doing those activities that are constitutionally enshrined and protected. So the Gardaí are the upholders of the law. They must actually ensure that we're allowed to engage our rights and freedoms in society without interruption. When the guards themselves become the interruption and the source of harassment, then the system is broken. And that is what has happened. Because Section 113 and 114 of the Criminal Justice Act 2006 are allowing guards, theoretically, of course not lawfully, to come out with adult behaviour warnings and start telling people that even though they're behaving perfectly lawfully, they must stop doing something that's perfectly lawful to do. You see, it's already exposed when a guard doesn't have the authority to arrest you, that a court doesn't have the authority to tell you to stop doing what a guard couldn't arrest you for. It's really that simple. You see, I was arrested before and put in Clover Hill prison for 6 days on the basis that I was told to leave the area and refused to do so, being that I had a reasonable excuse not to comply with the order to leave the area, because I hadn't breached any of the laws in that section. So, I think it's 3, 4, 5, 6 and 9. I hadn't breached any of them, including 7. I think it's not, section 8 is the order to leave the area. So, yeah, so I hadn't broken any of them. It was shown by a court of law, even after I'd been in prison for 6 days, that I had a reasonable excuse not to comply with the order to leave the area, and I hadn't broken any laws. So, knowing this, the judge ruled that I had a reasonable excuse not to comply with the order. So why would I ever again think that I didn't have a reason not to comply with an order telling me that I couldn't preach? So on the one hand, the court judge of the district court is saying, no, you do have a right to preach, and another judge of the district civil court is saying, no, you don't. And the police, on the one hand, in the High Court, the judge is ruling that police can't prosecute because they're not lawyers, and on the other hand, a court is ongoing that's on the basis of the prosecution of a superintendent. So how can they carry a court case that begun with a guard breaking the law after the High Court has ruled a guard cannot prosecute? How can they carry on a court case that says a guard represented the evidence of another guard, when at the same time in the High Court they're saying a guard is not permitted by law to represent the evidence of another guard? So 2 activities were integral to the initiation of these court cases that now stand against me, which are outlawed. A guard prosecuting and a guard representing the evidence of a colleague who's not present. Both of these activities are against the law in Ireland. And it has been recently reaffirmed in the High Court by a High Court judge. Yet, would they even fail to test the constitutionality of the sections under which those guards were told that they could prosecute? Would they even fail to remove those sections of the so-called legislature after the ruling of the High Court that says guards cannot prosecute? So obviously, if guards can't prosecute and they can't represent the evidence of another guard, the compiling of adult behaviour warnings in order to bring you into a civil court outside of a guard's jurisdiction, even if it was the criminal court, they still wouldn't have done so correctly, because a guard cannot prosecute and a guard cannot represent the evidence of another guard. It would allow for conspiracy, because if 2 guards are allowed to get together or 3 or 4 guards are allowed to get together and represent, and one guard's representing the evidence of 4 guards, separate evidence acquired on separate days. So, for example, the superintendent is required to get the evidence of 4 other guards and then bring that together, assuming that what they've said is true, knowing that they've conspired together in order to bring this person, to summons this person before the court. So section 113, 114, 115 and 117, all these sections of the Criminal Justice 2006 have recently been ruled unconstitutional already by the High Court. even just in those two parts, it makes them functionally unlawful, because the superintendent cannot represent the evidence of somebody else. He's not allowed to. He's not a lawyer. He's not a prosecutor. He's not allowed to do that. He's not qualified to do that. And that's recently been ruled upon in the High Court of Ireland. A guard cannot prosecute. He's not a lawyer, and he can't represent the evidence of another guard. So what the adult behaviour warning requests a guard to do is, imagine now the guard isn't there. He hasn't been there. He hasn't observed any evidence or anything of the day. He merely gets a phone call. He shows up on the basis of a phone call. He brings an adult behaviour warning with him. Well, that has shown premeditation. Even having the adult behaviour warning form with him has shown a degree of premeditation and conspiracy with the complainant. Because he has had to take the complaint of the complainant, which is merely a civil disagreement, and then he has taken down their complaint and ratified it with a signature, such to give the impression that it has the apprehension that if you don't comply with it, you'll be brought before a court, if enough of them are administered. So one guard on one day administers hearsay, another guard on another day administers different hearsay, another guard on the third day administers different hearsay, and then a fourth guard on the fourth day administers different hearsay, and they're all on the basis of a complaint being assumed as truth and presumed as truth, when there's supposed to be the presumption of innocence. So they're supposed to presume that what is written isn't true. That's not to assume that the person who said it is a liar, because that would also forgo presumption of innocence. It's to presume first that all parties are innocent, until one or the other is proven guilty. You see, just because somebody says something doesn't make it true. As, of course, it would be expected that a reasonable-minded guard would know this, having done one day as a member of An Garda Síochána. All their training is based on people breaking the law. So if people break the law, people lie. So they have to assume that people are innocent until they can be proven to be guilty. Why? Because people can lie about what other people do. So here they are foregoing all of the functional precepts and basics of law, which are necessary for the carrying out of law, and presumption of innocence, impartiality, jurisdiction, and everybody being held equal, are fundamental and integral to proper function of law. So any section that would forego any one of these parts or fundaments is, of course, unlawful and actually pitched against proper order in society. So if they're going to pitch these things against proper order in society, they have become the enemies of the state. So on the one hand, the High Court are failing to admit their testing the constitutionality of the sections 115 and 117, 113 and 114, but on the other hand, they already have, because they've ruled against a guard being allowed to prosecute. And adult behaviour warnings integrate the necessity for a guard to prosecute. So that means they're automatically unlawful. The adult behaviour warnings require a guard to represent the evidence of another guard. They actually require guards to get together and conspire on the basis of complaints, nothing more than prima facie evidence. That is, to require a guard to represent the evidence of another guard. Otherwise, how can the guard bring his evidence forward? And then how can they contact the superintendent if they don't conspire together and assume that each other's evidence is true? One might say, well, no, they're going to have their opportunity to prove whether it's true or not in a day in court. Well, no, they're already basing a summons on their conspiratorial gathering of evidence. which they're not allowed to do, because none was there for the gathering of the other's evidence. So they're not allowed to represent in any aspect or to any degree or extent the evidence of another member of An Garda Síochána, especially when the evidence is merely a complaint gathered on different days by different members of An Garda Síochána. So they're not allowed to represent hearsay as evidence. It's simply not evidence. It's merely standing at the side of the street and then somebody saying, da 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 da, I don't like him saying this. Well, or he said that. He said something racist. Okay, can you prove or give any example of what he said that you'd consider racist? No, not at the moment. That's what was said in court. The woman didn't have any example of me being racist. Yet it was printed in the local newspapers. Homophobic, racist. And I was brought into the court in the first place on the basis of hearsay by a member of An Garda Síochána summoning me to court to prosecute me, when he's not allowed by law, as it has been ruled by the High Court, to prosecute anybody, because he's not a lawyer. And they're not allowed to represent the evidence of another member of An Garda Síochána because it's against the law in Ireland, and that has been recently ruled upon by the High Court. So knowing this, knowing that the testing of section 113, 114, 115 and 117 would expose this, they're still running away from doing so. Even though they, functionally, they already have tested the constitutionality of section 113 and 114 and found them unconstitutional. Why? Because they've said that a guard isn't allowed to prosecute. Well, what does section 115 and 117 require a guard to do in a court? Prosecute. So what are they? Unlawful. What's that mean? They should be removed. And the High Court, now knowing what they know, must do it. They're already exposed. If they continue to fail to remove those sections, they are knowingly breaking the law now. Because the High Court of Ireland have said, we must and should test section 115 and 117 of the Criminal Justice Act 2006 for their constitutionality. They must. They're acting so unlawfully now by continuing this harassment of my life on, knowing that the fundamental sections under which all of these court cases began are unlawful. A guard is not allowed to prosecute somebody in a court of law. This has been ruled on by the High Court of Ireland and is available on lawsociety.ie to check. I can put it up on my Facebook again. I'll put the link in the description. You can see that the High Court of Ireland have ruled that a judge cannot permit in his court a guard to prosecute. A judge cannot permit in his court a guard to represent the evidence of another guard, least of all for a guard to represent merely a hearsay report of a citizen as something he would prosecute on the basis of. When not even a lawyer could do that. You cannot assume hearsay as evidence. It's considered prima facie evidence, and that's using the word evidence loosely because it's something submitted to the court. So it's considered evidence. Anything spoken before a judge is considered evidence if it's not just a clerk speaking administrative organization. But if it's considered something that could contribute to the case or colour the judge's opinion, it's considered evidence. So if it's prima facie evidence, it's merely hearsay. And for that reason, it cannot lead to a ruling against somebody on its own. It has to be accompanied with or by solid, irrefutable and substantiated evidence, in other words. solid irrefutable evidence or substantiated evidence. Substantiated evidence is evidence that can be proven. Now, if you can't prove the evidence, it cannot lead to a conviction. It's period. So and it cannot lead to any reduction of your rights. So somebody telling you can't sing or record or anything of that nature is totally unlawful in the absence of any lawful reason to tell them they can't do it. So being that it's your right to sing, speak and record in public, no judge of any court can tell you you can't do it. And I said that before the Court of Appeal. The prosecution is unlawful because it was done by a member of An Garda Síochána who's not lawfully allowed to do that. A guard cannot prosecute. It's been ruled upon by the High Court of Ireland, yet Section 113, 114, 115 and 117 of the Criminal Justice Act 2006 ask a guard to operate outside of his jurisdiction, forego presumption of innocence, forego impartiality, forego due process of law, and take on the role of prosecutor when the High Court has ruled that that's unlawful. The High Court has ruled that a guard is not allowed to represent the evidence of another guard, yet here we see guards accumulating evidence, acquiring evidence, loosely, using the word evidence loosely again, because all they're acquiring, collecting, is hearsay, prima facie statements of the public. Then they're ratifying them as true with a signature in order to tell you to stop doing something they haven't observed you do, even though they're telling you that otherwise you're behaving lawfully. Imagine somebody saying you're behaving perfectly lawfully, but please stop doing what you're doing on the basis that Mary has complained to me. What? You're supposed to be telling Mary that I'm within my rights. Now you've become a mercenary personal representative of Mary, and you're now coming against Ireland. So it's Mary versus Ireland, not the DPP versus Stephen Tallon. It's An Garda Síochána versus Ireland, because they're coming against the rights of the citizen. If you don't see that, you're blind. If you think this is Stephen Tallon versus Ireland, you've been led up the garden path. This is An Garda Síochána versus the Irish Constitution. That's why they're failing to test the constitutionality of the sections, because An Garda Síochána has gone rogue and are now serving a global elitist agenda. They've now become mercs of Freemasonry. They've now become their henchmen. They're basically an unruly mob that aren't complying with the laws of the land and need to start complying with the laws of the land, or they could find themselves in prison. It has been ruled upon that in Ireland, you're not allowed to prosecute if you're a guard. Section 113, 114, 115 and 117 ask a guard to prosecute. So they're unlawful. Why are they not being removed when it has already been brought before the court, the highest court in Ireland? And they've admittedly said it remains an open question, and admittedly scheduled it for testing and then abandoned it. And admittedly, there's an appeal in the Court of Appeal. And admittedly, a barrister for the state is saying that testing of the constitutionality seems that it hasn't gone anywhere, doesn't have seemed to go anywhere, or to have gone anywhere rather. And so, if it hasn't gone anywhere, and they know this, why hasn't it been done? When it's already been decided by the High Court that guards shouldn't prosecute, when it's already been decided by the High Court that they shouldn't be representing the evidence of another guard. And if they're not to be representing the evidence of another guard so to prosecute, how can they be representing a member of the public so to prosecute and choosing sides in civil disagreements? By the way, I can disagree with you in public and not break the law. a disagreement is not a breach of law. I can have a different opinion or belief system to you and not break the law. You understand? See how simple it is? But here we see people breaking the law, called members of An Garda Síochána. Why? Because they're trying to prosecute people and see them imprisoned unlawfully. This is so unlawful, guys. This is high treason against our state. And unless the Court of Appeal very quickly put this down and acknowledge that the testing of the constitutionality should take place before any further appeal or ruling, they're now conspiring with those who have prosecuted outside of their jurisdiction. Even though the High Court have ruled that guards cannot prosecute, now the Court of Appeal are directly involved in that, and if they continue this, they're now also contributing to a breach of the law, being that they must know at this stage, and if they don't, they should, which means that they're inept and incapable of making a comprehensive ruling on this court case if they don't know. And that is that the High Court have ruled that guards can't prosecute, and that the sections 115 and 117 that first begun this whole court case, Stephen Fallon versus the DPP, are unlawful on the basis of what the High Court have ruled. Guards cannot prosecute in court. Period. Not in a civil court where they shouldn't be, and certainly not in a criminal court where they're supposed to be upholding the law and observing it. So, let it be observed that members of An Garda Síochána are not allowed to prosecute in court of law. That members of An Garda Síochána are not allowed to represent the evidence of another guard in a court of law, and they're most certainly, therefore, not allowed to compile separate evidences, none of which have been proven or gone through due process of law, in order to summon somebody so that they can prosecute them when it's been ruled by the High Court that they cannot prosecute anybody. Now, if guards can't prosecute in a court, why is the superintendent in the court trying to prosecute somebody? As it pertains to Section 113, 114, 115 and 117 of the Criminal Justice Act 2006. These must be removed in Jesus' name, because he is the one instituting all authority on the earth. The High Court of Ireland has already ruled, listen now, that guards cannot prosecute in court. Section 113, 114, 115, 117, those sections which they purport unlawfully have brought me before the court, are therefore unlawful, unconstitutional, and should be removed. On that basis alone, and there are so many more, but on that basis alone, the High Court have ruled those sections unlawful. Even though they've tried to avoid doing so, they already have. Because if a guard cannot prosecute, those sections are unconstitutional. Without doing any further investigation. If guards cannot represent the evidence of another guard, then those sections are unconstitutional. Why? An adult behaviour warning requires you to compile it with another adult behaviour warning in order to summons you before a court. Well, what has happened there? The superintendent has represented the evidence of other members of An Garda Síochána in the aptitude and the position of a prosecutor, which means that they have broken the law, which has been recently reaffirmed by the High Court of Ireland. So, let it be observed that the High Court of Ireland are breaking the law and the Court of Appeal are breaking the law, unless they throw this out and remove the sections which first saw this court case beginning, unless they make the proper compensations, unless, to my life and my good name, unless they do what is right, remove the sections under the Criminal Justice Act 2006. 113, the adult behaviour warning mechanism has to be thrown away. It's unlawful. A superintendent cannot prosecute in court. A guard cannot represent or compile with or conspire with another guard, representing his evidence as true, in order to require a superintendent to prosecute in a court he's not allowed to prosecute in, when he's not allowed to prosecute at all in any court, especially where he's out of his jurisdiction in a civil court. Let it be observed that unless the Court of Appeal of Ireland ordered them removed, and now that it's come to their attention that the constitutionality of those sections hasn't been tested, if they too ignore and fail to have those sections tested, they too are breaking the laws of this land and are coming against the Constitution and the laws of Ireland. The Court of Appeal are already coming against the High Court of Ireland. The state are already coming against the High Court of Ireland. Well, who are the state? Are the state no longer representing the interests and the rights of the individual Irish person? Of course. Are they no longer upholding or interested in the upholding of the law of Ireland? They must be. Otherwise they've gone rogue and are now committing high treason and are no longer representing the interests and of the Irish people. You see, it is absolutely paramount that members of An Garda Síochána don't prosecute. So anything that has come on foot of a prosecution of a member of An Garda Síochána must be collapsed and thrown out of our court system. They're not allowed to prosecute. Period. It's really that simple. Anything extant, anything ongoing that has come about by way of a prosecution of a member of An Garda Síochána is now thrown out of the courts by way of a High Court ruling. In Jesus' name. It's really that simple. And the adult behaviour warning system, all of that, requires a member of An Garda Síochána to represent the evidence of another guard and play prosecution, which they're not allowed to do. Any of those activities. It's been recently ruled by the High Court of Ireland. You can check it out on lawsociety.ie. Let it be observed. Because if this goes on, if they try to dig their heels in and claw their nails on the ground, all they're doing is committing high treason and harming themselves. Because it has been ruled by the highest court of this land that guards cannot prosecute, let it be observed that if the High Court continue to fail to test the constitutionality of those sections, knowing now what they know and having ruled in the manner in which they have ruled, they are committing high treason and failing to uphold my rights as an Irish person, therefore targeting my life and therefore committing heinous crimes against humanity and against the rights of an Irish person. Blessings in Jesus' name.